Yes! Hello, my beautiful friends. What an amazing day it is, and welcome back. I hope your weekend was outstanding and incredible, and you're bursting full of energy on this beautiful and amazing Memorial Day. We're very glad that you're here. We got business to attend to. We know that the government is a little bit slow today, but we got some court updates. We're going to talk about Memorial Day, obviously. President Trump was out and about over at Arlington Cemetery, so we'll go through some of the presidential memorials and the honoring of our fallen soldiers. We also will talk about the Supreme Court. We've got some Rubio business coming up that got filed in one of the deportation cases, which is quite good. And then we've got this concept that Democrats are apparently going to be targeting men. Good luck with that. We'll see how that works out for them. But we're getting into it today, my friends. And so very glad to be with you today. We are going to check in with the president and see what the president is up to. As you can see, Trump is honoring Memorial Day in multiple different ways. So we've got a presidential post. We've got a presidential post, an announcement on the website, a proclamation rather, and we'll go through some more at Arlington. But here is what the president posted today. In standard Trump fashion, we're celebrating Memorial Day with a post. He said this: "Happy Memorial Day to all, including the scum that spent the last 4 years trying to destroy our country through warped radical left minds who allowed 21 million people to illegally enter our country, many of them being criminals and the mentally insane, through an open border that only an incompetent president would approve, and through judges that we'll talk about who are on a mission to keep murderers, drug dealers, R'ers, gang members, and released prisoners from all over the world in our country so they can rob, murder, and R again. All protected by these USA hating judges that we'll talk about who suffer from an ideology that is sick and very dangerous for our country. Hopefully the United States Supreme Court and other good and compassionate judges throughout the land will save us from the decisions of the monsters who want our country to go to hell. But fear not, we have made great progress over the last 4 years, and America will soon be safe and great again. Happy Memorial Day, and God bless America." From your favorite president, number 47. Thank you, Mr. President. And I know there's a conversation about saying Happy Memorial Day, and it's kind of one of those things that might not feel right when a lot of people are mourning the loss of their loved one on this day. But I came across a great post I thought was a nice reframe on this from Jake Novak. He is over with Real America's Voice, 7 a.m. in the mornings, early in the mornings. He said, we're happy, like Trump is getting some condemnation for saying happy. He says the president began his Memorial Day message with happy. It's not happy, okay? It's not happy at all. And Jake Novak says, well, we are happy when our honored military dead get remembered and appreciated, all right? So, yes, I do say happy Memorial Day, you ignoramus, right? So I think that's a nice reframe on this. A lot of people have lost somebody, obviously, that they love and care for dearly, and it's a day of mourning and loss, but it's also a time to pause and remember the tremendous sacrifice that they made for us and the honor that is associated with that. So I can understand both positions on this, but we mean it when we say Happy Memorial Day with the utmost love and respect for those who served. The White House is also doing the same, saying, look, on May 24th, here's a presidential proclamation and a prayer for peace this Memorial Day. They write, Memorial Day is a sacred day of remembrance, reverence, and gratitude for the brave patriots who have laid down their lives in service to our great nation. Throughout our history, brave men and women have been called to defend the cause of liberty on foreign shores in defense of our homeland. Their noble sacrifices are marked by flag-draped coffins and the silent sorrows of those left behind. We must never forget those who have given everything for our country. America's Gold Star families, whose sons, daughters, wives, and husbands are among the honored, endure unfathomable heartache. Their loved ones selflessly gave everything to protect our sovereignty. They have our unwavering support, our deepest gratitude, and highest respect. The lives lost in war serve as a solemn reminder of why we must pursue peace through strength. We are eternally indebted to our nation's fallen heroes. On this solemn day, as we honor their sacrifice, the First Lady and I, President Trump, ask all citizens to join us in prayer that Almighty God may comfort those who mourn, grant protection to all who serve, and bring blessed peace to the world. In honor of all our fallen heroes, the Congress, by a joint resolution approved May 11, 1950, as amended under the U.S. Code, has requested the President to issue a proclamation calling on the people of the United States to observe each Memorial Day as a day of prayer for permanent peace and designating a period on that day when the people might unite in prayer. The Congress, by law, has also designated 3 p.m. local time on that day as a time for all Americans to observe in their own way the national moment of remembrance. Now, therefore, I, Donald Trump, President of the United States of America, do hereby proclaim Memorial Day, May 26, 2025, that's today, as a day of prayer for permanent peace. And I designate the hour beginning in each locality at 11 a.m. of that day, and that time is now, as a time when people might unite in prayer. I ask all Americans to observe the national moment of remembrance beginning at 3 p.m. local time on Memorial Day. I also request the governors of the United States and its territories at the appropriate time, officials of all units of government, to direct that on Memorial Day the flag be flown at half-staff until noon on all buildings, grounds, naval vessels throughout the United States under our jurisdiction and control. I also request citizens to display the flag at half-staff from their homes for the customary forenoon period. In witness whereof, I have hereunto set my hand this 24th day of May in the year of our Lord 2025 and of the independence of the United States of America, the 249th. Signed, President Donald J. Trump, our president. And so we pause at this time to remember and to pray. And we appreciate the president leading us in that. Amen. All right, so that is what we saw. We also got Pam Bondi had an announcement. Said, today, we remember the fallen heroes who made the ultimate sacrifice to keep us free. Let us honor their legacy today and every day and keep their families who miss them dearly in our prayers. God bless America. Thank you, Pam. Now, here was Trump and J.D. Vance along with Hegseth over at Arlington and the Tomb of the Unknown Soldier making their way to pay their respects.
Left turn.
Present! Arms!
Amazing. So we saw that after the procession, there was a speech by the president. The White House also posted this, saying Memorial Day is a sacred day to honor the heroes who made the ultimate sacrifice for freedom. They left their families. They never came home. A grateful nation honors our fallen. We will never forget. We pray for their loved ones and all Gold Star families. God bless America. Here was President Trump speaking about this at the Arlington National Cemetery today.
The sacrifice that they made was not merely for a single battle, a long ago victory, or a fleeting triumph, decades or centuries past. Their sacrifice was for today, tomorrow, and every morning thereafter. Every child that lives in peace, every home that is filled with joy and love, every day the Republic stands is only possible because of those who did what had to be done when duty called, and the cost was everything to them and to their families. Our debt to them is eternal, and it does not diminish with time. It only grows and grows and grows with each passing year. The greatest monument to their courage is not carved in marble or cast in bronze. It's all around us, an American nation, 325 million strong, which will soon be greater than it has ever been before. It will be.
All right, so that's our president with a very important message on this very important day. And so we pause. We appreciate the White House leading us in this honorable ceremony where we can pause and pay respect to the people who deserve it, the families, the men and women who made the ultimate sacrifice. We love our country and we appreciate pausing and thanking the people who make it what it is. So thank you to the president for that. Feels like we haven't had a lot of Memorial Day love over the last 4 years. It's nice to see that return. All right, so shout out to our veterans, shout out to our Gold Star families and all the men and women in the military who serve our country. We appreciate and salute you. All right, so that's the Memorial Day update. Now, we got business to attend to today elsewhere, my friends. Let's go over to the Supreme Court and see what's happening here, because this was a pretty interesting filing and decision that came out from Judge Amy Coney Barrett. Ooh, we'll read through this one. DEI scammers get crushed by the Supreme Court. We're going to go through this one in the case of SUSPENDS versus the United States. This is a situation where some people said that they were small disadvantaged businesses and they got these contracts from the government saying, we're going to go and be diverse in our sourcing of our business endeavors. Turns out they were liars. That didn't work out so well for them. They got charged with crimes. They took this case all the way up to the Supreme Court, and Judge Amy Coney Barrett is the judge who is delivering the opinion on the court. And we've seen some interesting takes from her over recent decisions from the Supreme Court. But this one just came down. It's an older case that was actually argued some time ago, but just decided this past week. And Justice Barrett, Amy Coney, delivers the decision. Here's the background on the DEI scammers. All right. We got Stamatios Kasousis and the industrial painting company called Alpha Painting. So we've got Stammy and Alpha. And what we've got here is a business that got 2 government contracts in Philadelphia, right? So take us back to Pennsylvania, Philadelphia. We've got this person called Kasousis and Alpha Painting. They got a contract. Both contracts required the participation of a disadvantaged business. You probably have heard of this. Small disadvantaged business, women-owned business, whatever, LGBTQ plus business, whatever. So you have to go and work with these disadvantaged businesses. And they would place bids. They would get money from the Pennsylvania Department of Transportation. But the promise that they said turned out to be an empty one. In addition to using the suppliers that was solely as a pass-through entity, they also, the scammers, submitted multiple false certifications to cover up their scheme. So although Alpha and their paint work met expectations, they weren't actually employing disadvantaged people, whatever that means. So they got busted. The government charged them with wire fraud. They said, wait a minute, you said you were going to give this to the disadvantaged people, but this was fraud. You got painting contracts and you didn't employ any of those people. So there's a theory called fraudulent inducement theory, where a defendant commits federal fraud when there's a material misstatement that tricks somebody into giving you a contract, regardless of whether the fraudster caused a net loss. All right, so the defense here from the scammers will say, well, so what if we didn't use the small disadvantaged business? It was irrelevant. It had nothing to do with the services that we're providing. Like, we didn't go hire LGBTQ painters, but so what? We gave you a great deal because we hired some straight white guys or something or whatever. I don't know what they were doing, but it wasn't small disadvantage. So, but it wasn't a net loss to you. Like, you guys weren't harmed at all. So who cares? So the Supreme Court came back down and they said, well, we have to ask ourselves, does there need to be a net loss? Does there have to be some sort of penalty, or just the fact that there was a fraud that occurred? Is that enough? They say it is. If you're saying you're going to use small disadvantaged businesses, then you got to do it. When 2 Philadelphia landmarks, the Girard Point Bridge, so our friends over in Philly, you may know what these places are, Girard Point Bridge and the 30th Street Station, they fell into disrepair. Pennsylvania Department of Transportation went to go get bids to restore these. So this guy, Kunesis, and the Alpha Paint Company, they submitted a bid for the project. Wow, they're big monies too. His bidding proved successful. With respect to the Girard Point project, he got a $70 million contract. Whoa, that's a big contract to a joint venture comprising Alpha and 2 other companies. The 30th Street project, Alpha and another company also got a $15 million contract, and that was nearly a third of the $50 million, right? So we're talking big money. Not like we're going to go paint a bedroom. Federal grants for the U.S. Department of Transportation was a large amount of that money. So the U.S. DOT, like we're all paying for this, right? So we're going, okay, you guys take this money. As a result, both the federal and the state government had to say, well, if you're going to paint $70 million worth of stuff, we don't want that many white dudes painting it. All right. So, well, especially if they're straight. So make sure they're not getting their work. Okay. Like, okay, fine. So relevant here, transportation requires that grant recipients like Penn establish and actively implement a disadvantaged business program. A disadvantaged business is, according to the DOT, is a for-profit small business that is majority owned and controlled by one or more individuals who are both socially and economically disadvantaged. And we don't even know what that means. Because the DOT aspires to have at least 10% of federal grant funding to disadvantaged businesses, it's an important part of this conversation. Now, consistent with this rule, the Department of Transportation required that the bidders for these two projects in Philly commit to subcontracting a percentage of the total contract amount, which would be 6 to 7%, to a disadvantaged business. Failing to comply with this requirement would be a material breach. You can't do that. Accordingly, as part of the bidding process, SCOTUS and Alpha, the paint companies, you got to give $6.4 million to this other company called Marqueas, and that's going to be a pre-qualified disadvantaged business, right? So, like, okay, yeah, we'll give it to Marqueas over there. Marqueas was a lie. As later memorialized in a commitment letter, Alpha and SCOTUS concocted a scheme in which Marqueas, this other company, would function as a mere pass-through entity. They have no disadvantaged people over there. The scheme operated as follows, right? They're like, oh yeah, we're going to give everybody lots of disadvantaged businesses. SCOTUS arranged for Alpha's actual paint suppliers, with whom he negotiated directly, to generate purchase orders that were billed to this other company. So they probably like, oh, well, Hunter knows how to set up shell companies. So we'll just set up a shell company and we'll say that's a disadvantaged business, and then they can buy the paint and we'll just funnel it through them. When Marqueas got an invoice, it tacked on a few percent fee and then forwarded the inflated invoice to the main company. He then issued two checks. He would pay one back to the company for its markup and then the other to the actual cost of the supplies, right? So Marqueas was no more than a paper pusher. He was funneling checks and invoices, and it was just a fake scam. Not only did this arrangement contradict the prior representations, it also contravened the rule. You must perform a commercially useful function in your small disadvantaged business. So the scheme initially went undetected. As projects progressed, he reported, oh yeah, no, we're getting qualified payments. They're like, are you giving this to a small disadvantaged business? Like, yeah, totally. Here's the receipts for it. It's all right here. The Pennsylvania Department of Transportation, satisfied with the paint and repair work, they paid it. They're like, yeah, great job. Everything got painted. By the time the last coat of paint had dried, Alpha made $20 million bucks. And Marqueas, for its pass-through services, had pocketed $170,000. But once the deception came to light, a grand jury indicted the company and the dude for wire fraud and conspiracy to commit the same. After a trial, the jury found them guilty, 3 counts of wire fraud. But they moved for a judgment of acquittal. They said, you can't prosecute us. We didn't do anything wrong. Our paint work met the expectations. So what if we didn't give that to small disadvantaged businesses? There was nothing harmed you. Penn DOT had received full economic benefits of the bargain. Like, in other words, we complied with the contract, and the lack of a small disadvantaged business participation didn't matter at all. You guys weren't defrauded of anything. There was no money or property that you lost as a result of us just reorienting this money. Now, the lower level court rejected the argument. Court of Appeals affirmed, said, nah, sorry, you guys are guilty. As both courts explained, obtaining the government's money was precisely the object of the scheme. Like, the fact that they got the money, that's enough. It doesn't have to do with the work. The scheme targeted the money because the agency paid for services that they thought were going to come from disadvantaged people, and that didn't happen. So that paint sucks now. The circuits are divided over the validity of a fraud conviction when there was no actual intent of pecuniary loss, like financial harm. Several circuits have said no, the conviction may stand. Like, the fraud doesn't have to result in an actual financial harm. We granted cert to resolve this split to figure this out. If you're going to be charged with wire fraud and these other crimes, Do you actually have to have caused a financial harm to the other people, or could just the receipt of that money be enough for the fraudulent inducement and enough to charge a person with? Now, to convict, the Supreme Court, Amy Coney Barrett writes, to convict Alpha and Cousisis, the government needed to prove the following: that they used the wires to execute a fraud with false representations. Now, despite the use of the disjunctive or, okay, like or, they're going through the statute, you can execute a scheme or artifice to defraud or for obtaining money. She says, well, we've declined to interpret that of establishing alternative pathways to a conviction. Instead, we read those two clauses together. And we have held that the money or property requirement operates as a limitation on the former, right? So this is the thing with statutes, right? Statutory construction, it can be very confusing, and different courts can have different interpretations of a literal word, right? Or, like, what does that mean? They say, well, it's actually not like you can do this or you can do this. It's this with the limitation of this. It's not two separate independent clauses. One's actually acting as a limitation on the prior clause. A defendant commits federal wire fraud, in other words, they're going to explain, only if he did all this, both engaged in deception and had money or property as an object of the fraud. This is how they've interpreted before. So the money or property requirement lies at the heart of the dispute. Although the lower courts once interpreted the phrase money or property as something of a catch-all, Supreme Court says we recently reiterated that the federal fraud statutes only reach traditional property interests. Schemes that target the exercise of the government's regulatory power don't count. Got to have some financial component to it, nor do schemes that seek to deprive another of an intangible interest that is not connected to property, right? That provision of the law doesn't apply to these other cases. Now, in all cases, because money or property must be an object of the fraud, the traditional property interest at issue must play more than some bit or part in a scheme. It's got to be the aim. It can't just be incidental. And so from all of these rules, the defendants here, Alpha and the fraudsters, they attempt to glean another. They say, okay, look, if you combine all these things, like it's not as simple as there was just a fraud. It's got to be a fraud plus this, this, and this, and they were not harmed, so it doesn't meet the elements. But the theory under which they move cannot stand. They say a federal fraud, their argument, cannot stand, they argue, unless they sought to hurt the bottom line. Like we had to actually intend to defraud you in a way that was harmful to you. But the theory under which they're prosecuted, what they call the fraudulent inducement theory, doesn't actually require economic loss. Both parties describe it. The theory suggests anytime you use falsehoods to induce a victim to enter into a transaction, that's good enough. In these situations, the defendant need not, given the reciprocal nature of most transaction, does not aim to inflict economic loss. And because Alpha and Cousisis did not intend to do that, they say their convictions are invalid. Like, we didn't intend to actually harm them. Okay, that doesn't matter. That's not the requirement, says Amy Coney Barrett. We're not convinced. The fraudulent inducement theory is consistent with the wire fraud statute and our prior precedent. And so there doesn't actually have to be an economic loss in order for there to be a fraud. Look at the facts of this case, she says. By using Marcaius, which is that third company, that third party like shell company, as a pass-through entity, they devised a scheme to obtain a contract. They said, oh yeah, we're going to get disadvantaged businesses in here. They got tens of millions of dollars. And how did they do that? By making a number of false and fraudulent representations. They said, yeah, well, we're going to buy our paint from this disadvantaged business. And they didn't do that. And so they met the statute. The statute requires nothing more. Their contrary view rests on the premise that a scheme cannot be wire fraud unless there's more harm. But that's not what the statute says. It says to obtain otherwise, something means to gain or possess. She looks up the dictionary. She says, an art collector who acquires a rare sculpture can rightfully say that she obtained it, not if she stole it, I guess. And because of the meaning obtained doesn't return on the value, an art collector can say whatever they want because the art price is dynamic. Now, in short, the wire fraud statute is agnostic about economic loss. And the statute doesn't even mention it, doesn't require it. And so a conviction here comports with the law. Amy Coney Barrett explains what the common law said about a lot of this. We'll fast forward through it, going through a lot of precedent here. Now, regardless, cases involving deceit are inopposite from the question presented here. So let's summarize, she tells us. Common law courts did not uniformly condition an action sounding in fraud on the ability of related to loss. More specifically, if the action was one for rescission or a prosecution for false pretenses, the required injury ordinarily did not need to be financial, and that's the death knell for these defendants. The old soil principle does not apply. We don't have to go to the old rules if we have a new rule that's perfect for us here. And we do. It's all here. Even Alpha and Casesis concede that common law did not require economic loss. So they're like, well, even if we go back far enough, it's not exactly in our favor. And there is none. After all, animal, horse, sound horse, the horse, going through another case is what she's doing. Now, they contend that the fraudulent inducement theory is at odds with other aspects of our precedent, but she says, no, they're not. They're perfectly in sync. And we're not undermining our prior case law. They also warn that the consequences of this, if we set this as a rule, there's going to be a lot of problems here. They say under this theory, if this is the rule, every intentional misrepresentation designed to induce someone could be a property fraud. And they say no. That materiality requirement narrows the universal action, universe of actionable misrepresentations. So this is not going to create some big problem where everybody, I was frauded, I was defrauded, and everybody's going to be prosecuted. No, it's got to be a material fraud. So it's got to be like what you did, like tens of millions of dollars coming into your coffers when you said you were going to move it one way or another. So because the Third Circuit's judgment is in alignment with the law, we affirm it. It is so ordered by Amy Coney Barrett. Now, Justice Clarence Thomas is also coming in a concurrence on this. So he is joining with the majority. Says the court correctly rejects the request to add in, right, to write into the law some new economic loss requirement. He says, no, it doesn't require that. And so I join the opinion in full. But I also want to talk about this material thing. When the government prosecutes a defendant for wire fraud, we have to talk about materiality. Because they have not contested that their misrepresentations were material, we're not going to pass on that issue, but I am skeptical that their misrepresentations were material. Oh, interesting. So Clarence Thomas is saying, well, yeah, he's like, so what if they didn't use small disadvantaged businesses? All right, that's fine. He says the statute doesn't require economic loss, so they're properly prosecuted here. But the materiality component of this that they are kind of hanging their hat on, like as a protection that this won't turn into a big thing. He says, I'm not so sure this actually was material. He says they entered into a contract to repair the bridge. Okay, the contract purpose was paint the bridge. The bridge got painted. Requiring it to go to small disadvantaged businesses who are whatever percentage, whatever, that's not part of the contract. The purpose of the contract was to paint the bridge. To achieve these goals, what they need to do? Paint the bridge, structural steel repairs, roadway constructions, miscellaneous government projects, and more. Clarence Thomas writing, the contracts for these two jobs totaled more than 1,000 pages and numerous regulatory, technical, and ethical obligations and all this crap. Among other things, the agreements required these fraudsters to abide by the Workmen's Compensation Act, buy American provisions, use steel, generally avoid using convicts as labor, and also not to discriminate. Oh, look at this, right? So they say, wait, Clarence Thomas probably has a better argument here. Well, they have to also follow the law. And there's other workmen's compensation acts, and they can't discriminate on the basis of race, color, national origin, or sex. So the small disadvantaged business, what is this? The contract's also required to apply with the DBE program, the Disadvantaged Business Enterprise, saying that was established in 1983. It sets a goal that at least 10% of federal funds be expended with small business concerns owned and controlled by economically disadvantaged individuals, which is 51% owned by somebody who is economically disadvantaged, whatever that means. The DOT defines that term, socially and economically disadvantaged, primarily on the basis of race and sex. Oh, yeah. And the other law says, wait, you can't discriminate on the basis of race and sex. It's strange. And then the law says, oh, actually, you have to discriminate on the basis of race and sex. Don't give it to white dudes. No paints for white dudes. Put the roller down. The program rebuttably presumes that any member of certain enumerated races that have been subjected to racial or ethnic prejudice or cultural bias within the American society is a member of that group and thus qualifies because of his or her identity. Wow, that's very gendered language in our statutes. Wow, what if you're non-binary? Says among groups presumptively eligible. Oh, look at this. Black Americans, you get an extra handout. You get a quota provision from our government. Our government said, don't be racist or judge people on their skin color, race, or ethnicity, like Civil Rights Act, Martin Luther King, all that stuff. But then special carve out for Black Americans, Hispanic Americans, Native Americans, Asian Pacific Americans, and subcontinent Asian Americans. Oh. So the Asians are also a problem too. White guys, not small disadvantaged at all, no matter what happened in their lives or whatever their experience was in the world. They're fine. The, crack epidemic or reverse racism or affirmative action or whatever is not disadvantaging white people at all, or especially white dudes, and also not certain Asians. You have to be a subcontinent Asian American, or you have to be Asian Pacific American. I don't know what the other ones are. So it's curious. A couple other groups are not in here. Indians, Indian Americans, not in here, generally speaking. Some other groups. Interesting list here. Now, the DBE program also provides this favorable presumption to women, not dudes. DBE certifiers may not question claims of group membership as a matter of course. So if you're like, hey, it's interesting. I'm starting to think this should be a small disadvantaged business show. You know what I'm saying? Maybe we can get $70 million or something. We're small disadvantage. You're a white dude. Nuh-uh. Section 26.67A3 says you may not question the claims of our membership in the matter of a group. Okay, so it's insane. It's ridiculous. Thus, in practice, being certified as a minority certification to get presumptive status, writes Clarence Thomas, as the owner of a disadvantaged business, operates on the honor code, as the information is rarely verified. And how could you verify that? You'd have to you'd actually have to check their ethnicity. Are you black? You kind of look black, but I'm not positive on this. Are you like that one woman who was running in the NAACP, who's not really black, but she says she was black? There's a whole documentary on it. Who's going to verify that? Yeah, okay. You look pretty white, but I guess if you say so. While those excluded from the DOT's list of presumptively disadvantaged groups may attempt to prove sufficient disadvantage, the application process is a high hurdle. For example, here you go. A white male claiming to have experienced employment discrimination must submit a declaration about personal narrative, providing evidence that his status or limited opportunities to earn income from specific prejudicial acts were directed at him because of his distinguishing feature as being a white dude. Yeah. But you may attempt to prove those, but they're excluded. Interesting. Okay, so you can prove it if you're a white guy, but good luck. So the DOT incorporated the goals into both contracts in this case, even though the other law says don't discriminate against anybody. But in this case, it's allowed because it's just white dudes. So as the majority explains, petitioners are misrepresented their compliance with those provisions. That's true, but the government prosecuted them, saying that was fraud. The jury convicted them, and they got 6 years in prison for that. Now, although the court leaves the question of materiality for another day, we need to talk about it here. Materiality is an element of the government, and they must satisfy that. Now, the government says the standard for materiality here is articulated in another case law, and he says, okay, it has to go to the essence of the bargain. Okay, the essence of the bargain is not about using non-white males to paint the bridge. It's about painting the bridge. That's the contract. The government doesn't need to get involved in this crap where they're saying, okay, only black people from this location or only subcontinent Asians from this location. That's not the bargain. That's not the essence of what's happening here. We need a bridge painted. paint the bridge, get a roller. I don't care what color your skin is, get the job done. I seriously doubt that the DBE provisions can meet this standard because that's not the essence of the bargain. Saying, Clarence Thomas writes, we rejected other limitations in this other case, and we talked about materiality. Even in the face of a contrary contract, materiality cannot be found where there's minor or insubstantial non-compliance. A white guy, or I don't even, it may not be white, like Caucasus or something, you know, maybe it's white, I don't know, you know, like Greek or something, maybe it's a small biz, I don't know what it is, but it's not an approved ethnicity. It's not an approved, you know, group. So they got prosecuted, but so what? The bridges got painted, they were thrilled with the work, so what? A party's actions may reveal that a contract term is not material. If the government regularly pays a particular type of claim in full, despite actual knowledge that other minor things have happened, we've allowed that to happen, applying these familiar and rigorous principles, this is not automatically material. They got to prove that this is a real problem. Now, the court reserved the question on this for another case, but the standard we articulated is going to raise this into question. He says, let's talk about this case specifically. Clarence Thomas writes, the contracts in this case were for bridge repairs. The contracts were not to go hire minorities. There are several reasons. This is a black man writing, okay, so don't get mad at me. There are several reasons to think that the DBE provisions did not go to the very essence of the bargain. First, the DBE provisions were irrelevant to the contract's fundamental purpose, which is bridge repair, which suggests that they were the sort of minor or insubstantial conditions that were not material at all. As the Third Circuit also recognized, although petitioners did not meet their conditions, they did a good job. They delivered the requested work. The quality of the workmanships and the materials were all uncontested. If the DBE conditions, the disadvantaged business, if they went to the very essence of the bargain, the failure to meet those conditions would have impacted the final work product. But the final work product, which was the bridge being repaired, was not. The conditions here had no bearing on their ability to complete their project. That disconnect tends to support the conclusion that those requirements were not material to the performance of the contract, and so therefore they can't be criminally charged. Second, the DBE provisions appear to have been less important than in the contract terms than the actual repair. Like, do you want the bridge to be done, or do you just want minorities painting things or something? Like what do you want? What is the primary purpose of the contract? It's to paint the bridge, says Clarence Thomas. 10%, 6% of the others was going to minority or disadvantaged individuals, but that's not the crux of the claim here. The contract required the DOT to deduct payments due to their work if the job was done unsatisfactorily. While the contracts labeled the failure to comply a material breach, they said that may result in termination. So it's not automatic. As explained in other cases, we've said that there needs to be more. But the business fraud is so prevalent, if the fraud is so prevalent that the government would have to assume a significant number of contractors violate the provisions, that again would say cast doubt on the materiality. There's a lot of reports of fraud in the DBE program. There's no exception here. Fraudulent DBE schemes where minority and women contractors are used as false fronts is an area with serious enforcement and compliance problems. Legislators have recognized this problem. Looking at this from the viewpoint of the prior law, this program could suggest that a reasonable contractor could follow the contract language and actually believe that DBE was not essential. It's like a recommendation. Yes, we'll try, but you want us to get the job done, right? So if we can't go find these things, would you rather us not paint it with white people, I guess, with non-disadvantaged people, or not? And we completed the contract, which was the end game. If complying with the provisions would violate the law, it's also difficult to see how representing the compliance would be a wrong inducement Clarence Thomas raps, he says, I am skeptical that the government could meet this bar and that these guys could be convicted. While the government has not been put to the test in this case, it appears to have elsewhere endorsed the program's race-based benefits on the ground that minorities represent more than 20% of the population, but they own only 9% of all construction firms, and they receive only about 5% of construction receipts. So I guess our government then has to correct the marketplace and make more minorities own businesses. Maybe they don't want to. Maybe that's not their profession. Maybe they got other industries, but the government says we're going to correct this. But proving a broad sociological proposition by statistics is dubious business, says Clarence Thomas. And at least one court has said that the DBE policies are in fact discriminatory. He's also saying it's also implausible to think that a reasonable person would attach importance to contract provisions that mandate constitutional violations. Here we go. If the government cannot demonstrate that the DBE program, which requires you to categorize people by race and ethnicity, literally, they wrote it down in the list, subcontinent Asians are only allowed. I doubt that it's constitutional. I doubt that a provision requiring compliance with an unconstitutional program that chops people up based on race, that is not reasonable to comply with that. At bottom, says Clarence Thomas, the essence of the bargain standard is rigorous and it's context specific. The bargain was the bridge. Although the contracts in this case are riddled with DBE crap, we have made clear that the materiality inquiry turns on substance rather than labels, and that focus may doom these prosecutions if there is a material problem. Now, in persuading the court to reject the economic loss arguments, the government has assured us that, yeah, the essence of the bargain standard for materiality will ensure that you're not going to just start prosecuting all these people. But the materiality standard was not met here. And saying lower courts should hold the government to its word. Justice Gorsuch also concurring in that. Let's see if there were any dissents here on this one. So Gorsuch is concurring, and it looks like Sotomayor is concurring on this in the judgment, and that's the game. So we got no dissents on this, so it looks like it was 9-0. So at least concurring in the judgment. So interesting case there. And I think Clarence Thomas is probably the closest to being right on that. Obviously, we don't want anybody defrauding the government. If you're going to say you're going to do something, we want you to do those things. But in this case, they were asking them to comply with stuff that is clearly unconstitutional. And we have the now trading card game where they're treating people like trading cards. Like, hey, you get one of these, you get one of these because we've got a black company over here. We've got a gay company over here. We've got a women company over here. But all the white dudes, you're not disadvantaged at all. Just shut up. And that whole scheme should be subject to strict scrutiny. We're classifying people based on gender and race and ethnicity and ideology and maybe religion if you're disadvantaged or whatever. And so it is something that should be looked at with a lot of scrutiny from our courts when they mandate those things as part of government contracts. We don't want our government coming into the markets and trying to create justice. They're terrible at it. They're morons. They don't know what they're doing. And they pervert everything from getting done. We'd rather have the government just say, here's a contract for business. The best people who can, to paint the bridge, the best painters can get it done for the best price and deliver a product, not deliver social justice and bureaucratic manipulations in our markets. They're not good at that. Clarence Thomas knows it better than anybody. And so an interesting decision here. The convictions essentially affirmed for these two. So they'll be serving their time. And we'll see if the Supreme Court continues to develop this area of law. Obviously, we got Gorsuch, Sotomayor, and Clarence Thomas, who are not entirely on board with the majority. And there's a question of materiality. So a good decision from SCOTUS. As always, we'll keep our eye on what's happening in that docket. Thanks for subscribing and joining as we do. All right, so good update on that one. Now, let's talk about Rubio and these deportations, because this case is getting hot in Massachusetts. And so let's get into it starting now. A fiery battle in Massachusetts is brewing, and Marco Rubio has come in on this saying, hey, Judge, listen, I am the Secretary of State, and I am entering a declaration to you explaining why your mandates, where you have issued injunctions and orders and required us to bring people back to the country after they've been deported, is wrecking our foreign policy, making my job more difficult to do. And the judge in this case, who obviously was not elected, is not caring or heeding any of this advice at all, and in fact is now ordering Trump and Rubio to bring this dude back. OCG is ordered to come back. We're going to go through this decision that was written by this horrible judge known as Brian Murphy, saying Trump's got to bring this guy back, like now or else. And so as soon as the courts open back up after the holiday, we're going to see, I think, a lot of appeals and battles in this matter, because Rubio has communicated to the judge, you can't do this. And this was their final reply on this. Remember, in this case, Judge Murphy ordered them to bring this dude back. So Trump, Rubio, Kristi Noem out of Homeland Security, they responded to the judge. They said, can you please reconsider your horrific ruling? Here's why. Declaration from Rubio and a position from Noem. And here's what they said to this judge. Listen, Murphy, you're requiring us to bring back the dude who's, under attack because he's a gay man in Mexico. They're discriminatory towards the gays down there. And so we in America have to take all the prejudiced gays from all over the world in America, according to this judge. So here's what they write to him. They say, no. Defendants request that this court reconsider its order finding that Trump violated your injunction, right? They moved a lot of these people out. The judge said, don't do that. They already had final orders of removal, and they removed them. And it's extraordinary follow-on orders and your highly burdensome requirements. You ordered us to do this. We're asking you to reconsider, because this is going to be a problem, right? Because Trump might just say, no, not going to do it. So ask you to reconsider. Don't force us to violate your order. Because of this court's order, Trump and Rubio are currently detaining dangerous criminals in sensitive locations without clear knowledge of when, how, or when this court is going to tolerate this release. Now, this development has put impermissible, burdensome constraints on the president's ability to carry out his Article 2 powers. And we're not going to allow that to happen, including his powers to command the military, manage relations with foreign nations, and execute our authorities. Saying these detained people that this judge is ordering them to bring back or not remove have already enjoyed the full benefit of full process under the laws of our country. And they were lawfully removed from this country in accordance with this court's prior order. So don't tell us that we're violating any of your orders. And remember, just to be clear, many of these immigration proceedings, we've got two different court systems that we often forget about. We just think of the courts. We've got immigration courts, which are handled under Article 2. That's the presidential prerogative. We've seen the filings, Department of Justice, IJ, immigration judge, all run through Article 2 because they're not citizens, and the president has the prerogative, mandated by Congress, this is all statutory defined, to handle the immigration cases in the Article 2 courts. So what the judges are saying now, once these people have already been processed through the Article 2 courts, they've already got a final order of removal, all stamped off, due process, get them out. The only thing left to do is to get them and move them. They then, once they've been gotten or are already gotten, then they file another petition, and the judge says they have to reopen everything, right, in Article 3 courts, even though the process is over. So it's due process plus, right? They get premium protections. You don't even get those protections. They get multiple bites at the apple. You can try that. Oh, you've been convicted of a crime? Sorry, didn't like that. Want to go try it again in a different court and get a different outcome. That's what this judge is saying that they have to do. They're saying, no, we don't. We already did our job under the law. Under Article 2, it's done. So they say to correct these challenged orders, clear errors of the law, right? You don't get to make us do it all over again in your court. And to prevent the manifest injustice that this judge's orders have caused and will continue to cause, you should reconsider this, judge. In the alternative, we request that you stay these orders pursuant to the federal rules of civil procedure, which he's not going to do. And furthermore, in order to relieve these motions, we request a prompt ruling on this motion. Thank you, Judge. And we got it. The judge denied it. The court's April injunction You instructed us to provide class members with a, quote, meaningful opportunity to raise a reasonable fear claim after being informed they were being removed. Okay, so they already had their opportunities. In Article 2, the judge said, before you move them, give them another chance to say, I'm afraid of something. And then they did. I'm going to be attacked in Mexico all of a sudden. Got it. However, when the court issued the injunction, it didn't define or elaborate on what a meaningful opportunity is. And so on May 21st, the court said that we violated this because we gave some class members notice of removal to a third country and removed them when they did not make a claim. Like you said, give them an opportunity. We did. And we removed them. Then the court came back down and said, oh, well, what I meant was reasonable opportunity was 10 days. It said, what? 10 days? No. 10 hours is fine. You're going to go. Do you have reasonable fear? No, I don't. Great. Get on the plane. Let's go. Furthermore, with respect to 6 criminal alien class members, the court determined, he said, well, you didn't give them a reasonable opportunity. The court then imposed additional requirements. Specifically, Judge Murphy out of Massachusetts required Trump to continuously maintain custody and control of these people and provide each one of them with a reasonable fear interview in private, with the opportunity to have lawyers there during the interview, either in person or remotely. And remember, these are some of the worst, like ours, murderers, the worst people. Each alien must also be given the name and telephone number of the ACLU class lawyers, which you never get, free lawyers, as well as access to a phone, interpreter, and technology, and for a confidential transfer of documents, the same access they would get if they were in America. We read all that last week. Moreover, the Trump DOJ says each alien and class counsel must be given 72 hours of notice to make up their new claims. They're all going to make up new claims. The ACLU lawyers who've been appointed are going to come in and say, okay, do you have any fear at all? Like, no. Well, do you have like a pupusa business? What's a pupusa? They're delicious meat patties from El Salvador. Oh, yeah. My cousin has a pupusa business, and I forgot. We were under attack down there from a rival gang who wanted to take our meats. Oh, yeah, great, perfect. Write that down. For aliens whose claim falls short of reasonable fear, right? So even when the DOJ, Homeland, says, do you have reasonable fear? What is it? They say, no, I don't. I'm just here because whatever. They say, okay, you're gone. The judge said, sorry, your decision is not good enough. They still get 15 days in addition to that to then reopen their immigration proceedings. Reopen. They're closed. But the judge is going to give them a second bite at the apple. Okay. You get a DUI, you get a speeding ticket, you get something, you get convicted, you don't like it. The judge you go file with the judge. He gives you a free lawyer and gives you a second shot at it. Never happened in America because you're not an illegal alien and you don't get premium version of due process in America. During that 15-day period, Homeland must maintain the aliens within the custody or control and give them free lawyers from the gangbang ACLU. So DHS says, look, this is ridiculous. It's well established, okay? Federal court's reconsideration of its orders are warranted when there's a manifest injustice. Your orders are premised on an erroneous conclusion that we failed to provide meaningful opportunity for these 6 people. We allowed them opportunity that is eminently reasonable in the removal context. They don't get weeks to do this. Moreover, the orders infringe on the president's Article 2 inherent authority and the powers of the commander-in-chief, and they interfere with his duties to execute the law. And so you should reconsider your decision now. You, Judge Murphy from Massachusetts, erroneously concluded that we did not give them a meaningful opportunity, but we did. Your order said meaningful opportunity. You didn't tell us how long that was at all. And we interpreted it. The government informed the court that the definition of meaningful would be shortly before. We're planning to remove you. Here are your rights. Would you like to invoke your rights or not? Yes or no? No, you're gone. The government even went so far. Here's a quote. They say, before an alien is removed, and one of the people who's suing here, OCG, who's allowed to proceed anonymously, admitted to getting an example. So even that one dude says He wrote in his declaration, after I was taken out of the prison, the immigration officer told me I was being deported. Great. That guy had plenty of notice. The government even went so far as to suggest that the court could make legal findings and allow the agency to draft a proposal and then decide whether that was enough process. The court did not heed our warning. You didn't ask us to review the process at all. So we did what we thought was right since we're the executive branch. So we implemented your order. ICE provided notice shortly before removing them, and that notice was meaningful, and there was sufficient time to comply with all of this as written. These aliens needed only state, all they had to do was just say, I've got reasonable fear of removal to South Sudan. If they would have just said that, we would not have removed them. But they didn't. They didn't say it at all. They had notice, they had opportunity. Do you want to invoke? No. So they're gone. Therefore, Homeland attempted to remove these people who have committed the most reprehensible violation of our country's laws, and we've covered those before, to a place where they no longer pose a threat to us. They got plenty of process. Now, the opportunity afforded to these aliens to raise a fear claim was meaningful and reasonable. In fact, the law says, 8 U.S. Code 1225 says we can immediately, the statute says immediately remove them. We don't even need a hearing. We don't even need further review. There's a limited window in credible fear persecutions, not the 15 days that this judge has shoved in here. And even when an alien in an expedited removal does say that they're fear, if the fear is deemed non-credible, the statute says an immigration judge under Article 2, the laws say this, under Article 2, shall handle this as expeditiously as possible to the maximum extent possible within 24 hours. But in no case, no longer than 7 days. U.S. Code 1225B1B33. The judge doesn't care about it, gives them 15 days and a second hearing to reopen everything. The Supreme Court has upheld the constitutionality of this removal scheme. It's lawful. Comparison to this is directly on point. Both class members and expedited removal aliens have already been determined to be removable. And they would be making a fear claim in the first instance, right? The judge is giving them a handout. Hey, an assist, raise this claim, and here's an opportunity to do it. Accordingly, they got a meaningful opportunity. And you should not give them another opportunity and 10 days to meet with gangbanger lawyers to help them make up a claim. And by the way, Judge, you're interfering with the Article 2 powers. Even if the court didn't err with regard to meaningful notice, like even if you think that it should have been longer than we gave them, this is against the president's power. The president gets to manage foreign policy. You don't get to do that. The federal courts have no authority to direct the president to conduct foreign relations in any particular way, and you don't get the right to tell us how to engage with foreign sovereigns. That is the exclusive power of the president and the sole organ of the federal government when it comes to international relations. Now, you, Judge, are requiring us to maintain custody and control of these people in the South Sudan. This requirement has already had and will continue to have negative consequences to U.S. strategic interests, including in Libya, South Sudan, and more. We got a big redacted paragraph here explaining some of those consequences. Now, because cooperation with other nations is critical, your interference is going to cause problems in crises, and it's critical that we can do our job. Now, furthermore, Judge, your orders are also impermissibly disrupting the president's ability to execute the law. Saying the relief that you've issued, including mandatory notice and reopening cases to the most reprehensible of criminals, greatly interfere with the president's ability to do his job. Reaching agreements with foreign governments to take these people back is part of our key effort, and your orders are imposing logistical burdens that are impeding our job. Aliens scheduled for removal are located throughout the country. This requires coordination of multiple offices across the nation. On any given flight, Judge, there may be aliens being removed to numerous foreign nations. This requires ICE to coordinate multi-leg flights through multiple countries. Given the complicated nature of these things, it can take 30 days or more. And so in order to remove people, we need permission from the countries. We need clearances for the flight. All stakeholders must be on board. Homeland needs to be on it. Not all countries will accept these people. There's a lot going on here. And so every time you tell us to do this or that or the other, you're interfering with these logistical arrangements. You're messing with our ability to do our job. In interfering with the president's ability to execute the laws, you're also creating serious safety risks. If we cannot remove these people in time, there are problems. Even convicted R'ers are on these flights. In other words, multiple criminal aliens, in this case earlier, had to be released into the community because we couldn't remove them, okay, under the prior administration. So we're not going to do that. For all these reasons, we have to execute the laws. And if you're not going to reverse yourself, Judge, which he's not, then we ask you to issue a stay on this so we can appeal it. Signed here by the Trump DOJ, Civil Division, Matthew P. Seaman, over from the Office of Immigration Litigation. Now, Rubio also sent in a declaration. He says, listen, in case you want to hear it from the Senate-confirmed Secretary of State, I am the Secretary of State, Judge Murphy, the Chief Foreign Affairs Advisor. The statements made are based on my personal knowledge as the Secretary of State. And it's confirming, Judge, that your orders are causing significant and irreparable harm to U.S. foreign policy. Your order requires us to go get these people. It's already having negative consequences in Libya, South Sudan, and Djibouti. In Libya, the court orders have interfered with quiet diplomatic efforts and exacerbated internal political and security divisions in Libya, as factions opposed to the Prime Minister Dibeiba sought to capitalize on public reports of potential migration removals in Libya. Other political parties are now coming in here. Rival authorities based in Benghazi are now also saying, well, you're going to remove them. There's political unrest now that you're causing. In fact, new aligned forces took action against two large armed groups in Libya, and there was street fighting, the most serious since 2022. Judge, you're causing international harm and chaos. In fact, in South Sudan, says Rubio, the orders threaten to derail significant efforts to quietly rebuild a working relationship with Juba. Before the court's intervention, the government in South Sudan, which previously refused to accept the return of people, has now been working more cooperatively. Without their cooperation, moving humanitarian relief is also more difficult. It's not just about these criminal removals, it's also about other interfacing with the governments. The May 20th order also causes harm to Djibouti. Djibouti is strategically located in the Horn of Africa, sits astride the world's busiest shipping lanes, adjacent to at least several regional conflicts, terrorist organizations, and more. We got a joint task force over there and a military base. And now you're interfering with our ongoing diplomatic negotiations with them, Judge. The U.S. government aircraft also uses the Djiboutians. A flight bringing 8 individuals in there had to get approved by them. And your order interrupted the transit process, Judge. Required the aircraft to temporarily remain in Djibouti. And we had to explain that because you're ordering us around. Now, this situation is diverting from our efforts. We're trying to counter terrorism. We're trying to deal with multinational militaries. And you're wrecking our foreign policy. Disruptions as a result of your order, Judge, have broader negative implications. These disruptions could interfere with basic humanitarian assistance and in a time when we need it. Some parts of the region are suffering from famine, and so you're killing innocent Africans. It is therefore critical to maintain effective foreign policy, signed by Marco Rubio. Now, the judge doesn't care. He's the president. He only cares about gay illegals. He doesn't care about other people. And so this judge wrote this back. Judge Murphy, he says, oh, okay. Let's talk about the plaintiff, OCG. Says he's got no criminal history. And this is Judge Murphy writing in response to Rubio and in response to Kristi Noem. Says after suffering multiple violent attacks, OCG sought protection in the U.S., where an immigration judge granted him withholding of removal from his native country, Guatemala. So they sent him somewhere else. This means that they said he can't go to Guatemala. 2 days later, he was placed on a bus and sent to Mexico. Perfect. But he says, oh, I can't go back to Mexico either, a country where he was previously held for ransom and ARD, because he's a gay man, you know. Says OCG has said during his immigration proceedings, he was afraid of going back to Mexico and even presented evidence of violence he got there. That's great, but the judge didn't care. The judge said, don't send him to Guatemala, so they didn't. But the immigration judge told OCG that he could not be removed to a country other than Guatemala, just like Kilmar, at least not without some additional steps. And so those necessary steps and his pleas for help were ignored by the immigration judge and by Trump. And so he was sent to Mexico. And then when he got to Mexico, they sent him to Guatemala, and he's in hiding in Guatemala today. And we read through his declaration. He's like, I'm a gay man. If I go to the store, there's people on motorcycles who look at me weird. And so I need to come back to America because I feel petrified about whatever. And the judge is like, totally buying it, probably wants to invite him over for a margarita or something. I don't know. But this is the second time that they have asked the court to bring this man back. The first time, the court declined to do so. No, not going to require it. Then he contested this fact. They said the first time, defendant had submitted a declaration made under oath, Trump, that prior to his removal, that this guy said he had no fear of being sent back to Mexico. Now, he sent his declaration. He says, no, I also am afraid of Mexico. And the attorney is, no, he doesn't want to go to Mexico either. And just to be clear, right, withholding of removal before Trump came in was a practical prohibition on removal anywhere, right? They would say, okay, you can't be removed. We're just not going to remove you. There's a lot of other people who can be removed. But this guy, so the judge said, okay, Guatemala, and practically for him, that was non-removable, right? Same for Kilmar. But Trump came in and said, oh, it's just Guatemala, so you can go to Mexico. Kilmar was just Guatemala, so they sent him to El Salvador. Because of this factual disagreement, the court declined to credit this man's account and instead ordered discovery of additional evidence, right? The judge says, well, I don't really buy it. You're attacked in Mexico, whatever. Then last week, Trump said, actually, yeah, we don't have a person that said, or we don't have evidence that this guy said he was fine in Mexico. And so Trump says, no, actually, we don't have that. Hours before the scheduled deposition of the witness who could verify the facts, the judge wanted discovery, right? Oh, you said that somebody said that he was not afraid of Mexico? Who said that? Then Trump came back and said, actually, we don't have that witness. We don't have any basis for that in Mexico, but we don't care. The other judge said Guatemala. He doesn't get a second bite at this whole thing. So the judge comes back out and says, apparently they cannot find a witness to say that he was unafraid of being sent to Mexico. The only evidence before the court is his uncontroverted assertion that he was given no notice of his transfer to Mexico and no opportunity to explain why it would be dangerous for him to be sent there. And he sent the declaration in saying he's, gay. Defendants' retraction of their prior sworn statements makes inexorable the already strong conclusion that he's going to win because he didn't have due process. Absolutely ridiculous. He already did in his removal proceedings. And so the judge is going to open this back up again because he didn't get the chance to say he was scared of Mexico. Okay. He already had all of that with the withholding of removal to Guatemala. The judge admits it. Said he was afraid of being sent back to Mexico, but the withholding was for Guatemala. Accordingly, their motion is granted. So now, because he's now creating a new claim because of Mexico, that you have to reopen this. He said, mistakes happen, but the events leading up to this decision is troubling. The court was given false information, and you exacerbated that risk. You placed this dude's full name on the docket. He says, how dare you do that? So I ordered discovery to get to the bottom of this. Now, here's the background. OCG is a native and citizen of Guatemala, says the judge. In March, he broke into our country illegally. March 2024, he's like, oh man, Trump's going to get elected. I better get in there now. He says, well, I went to the border and I wanted asylum and I was denied an interview. Yeah, right. Broke into our country illegally. In any event, he was deported back to Guatemala. Then in April, so he comes across in March, gets caught, gets deported. Comes back in April, breaks into our country again. decided to try again and crossed into Mexico on his way to the United States. And on that illegal journey, he says he was attacked and arred and held hostage until a family member paid ransom. Oh no, so that's our problem now. So then in May, so he tries to come cross Mexico. Some Mexicans attacked him and held him for ransom. So then he's going to flee Guatemala again. He comes back in May. Again, arrived at the United States, picked up by Border Patrol. It's like a terrible illegal. It's like, oh my gosh, like 20 million people have come in here illegally. This guy can't figure it out. Sheesh. This time, however, he did go to an asylum officer. He says, I'm afraid of going to Guatemala. Third time's the charm. I already figured it out. He's like, oh, you have to say you're afraid of something. What? Guatemala. Okay. The officer said, oh yeah, you got credible fear of persecution. You're going to be tortured in Guatemala and initiated withholding proceedings. An immigration judge then came in, said, yeah, it's more likely than not, which is like the lowest standard ever, like preponderance of the evidence. Like 51% just like, well, yeah, you're going to be persecuted and tortured if you're sent back to Guatemala. Why? Is he a political exile? Is he an advocate for something? No, he's just gay in Guatemala. That's it. So during the withholding proceedings, OCG asked if he might be sent to Mexico. Well, I don't want to go back to Mexico either. The immigration judge says, well, we cannot send you back to Mexico, sir, because you're a native of Guatemala. During another hearing before the court, the judge also described in detail, the violence he experienced while in Mexico. So this dude, everywhere he goes, he's under attack. At the close of that hearing, the government's attorney clarified with the immigration judge. He says, because Guatemala was a country of removal designated on the order, that was the only country for the purposes of withholding, and the immigration judge agreed, okay? You get one country. You don't get like a million different countries. But practically at that time, before Trump came in, one country was all you needed, okay? Because the government wouldn't let you go. 2 days after being granted withholding and with no advance warning, OCG was put on a bus and sent to Mexico. And when was this? June 17th hearing. The judge didn't tell us what date that was. Let's see if we can parse through that. Granted removal. That's April 2024. Okay. So during another hearing, 2 days after that, he was sent to Mexico. Now, he begged the officers to let him call his attorney, but he was refused until 1 week ago. Trump then maintained that OCG verbally stated he was not being afraid if sent back to Mexico, but after speaking with them, now Trump says he doesn't make that claim. Now, in Mexico, OCG was given the option. You can be detained indefinitely while trying to obtain asylum there. And he says, I'm going to be attacked in Mexico, or you can make the decision to go back to Guatemala. We're going to keep you in custody in Mexico, and you can apply for asylum, or you can go back to Mexico. The very country from which an immigration judge said you can't go back to. This dude chose Guatemala. And he remains there today. Okay, this guy went back to Guatemala voluntarily, and the judge is mad that he's in Guatemala because another judge said don't send him back to Guatemala. We didn't. We sent him to Mexico. Just yesterday, he says he submitted a declaration. We read it. It was so pathetic. And if you missed it, he's talking about being gay. If he goes out to the grocery store, people on motorcycles look at him weird, and so he's going to get killed. Being unable to leave the place where he's staying. The police won't protect me because he's just probably a hysterical person. And not being able to see his mother because they're going to attack her too for having a gay son or something, among other hardships. The most ridiculous thing you've ever seen. The guy chose to go back there. Now he says, I'm gay, I'm going to be attacked, and the judge saying, bring him back. On March 23rd, Trump filed this action. I'm sorry, the gay illegal gangbangers sought this action, and the court denied this part of their request, saying there's a factual dispute. But then we noticed in discovery that they identified this guy, and there was a TRO. And so the judge says, here's the legal standard. Now they're going to win. The court has already addressed a lot of this. We have jurisdiction. We said they got specific warnings, but the court already said general warnings are meaningless. And this is the perfect example. He did present evidence of his fear of going back to Mexico during his withholding proceedings. The immigration judge, he even asked, can I have immigration judge for protection from Mexico? And he said, correctly in this court's estimation, that you don't need to worry about that. He only needed to worry about the country of removal already identified on his removal order. Now, in reality, his notice is a post factum notice is a distinction without a difference. As an initial matter, he could not have moved to reopen his immigration case because he got a new order of removal. But even if he could have removed to reopen, it's unclear precisely what precisely that motion would have said. Here, though, there was no new evidence. He's already testified about his violence. The awkwardness of trying to imagine how this issue might theoretically be shoehorned in, I don't know. But he says more fundamentally, they confuse his claim with the remedy. His claim arises when he was denied notice and didn't have an opportunity to present his fear-based claim, which he already did multiple times. The claim could not have been raised in immigration proceedings. Trump says that he might have been able to get that adjudicated some other way, but the court thinks is wrong. Even if he could, it would not alter the fact that his rights were violated, blah, blah, blah. The court finds he's going to win and gives us a lot of analysis. There's no irreparable harm for Trump if this is stopped. The court recognizes the public has an interest in stopping wrongful removal. So it's not that we want these bad people out of our country. It's that we don't want people wrongfully removed. That's the public harm. So in conclusion, the judge says all four of the injunction factors are going to favor a granting of this injunction. And so Trump is ordered, even though this dude chose to go back to Guatemala, Trump is ordered to take all immediate steps, including coordinating with the lawyers for this dude to bring this OCG back to the United States. Trump shall file a status report within 5 days as to the status of his return. The court exercises its discretion and the bond requirement and is not going to require a bond and is not going to require that at all. Signed by Brian Murphy, the dude who probably wants to have a margarita with OCG back in his house when he comes home, ordering him back home because he's under attack in Mexico. So basically, you can't deport anybody anywhere. The immigration judge said, don't send him to Guatemala. We didn't. We sent him to Mexico. Well, he's not a citizen of Mexico. So the Mexico government doesn't want to just let him go in their country as an illegal there. So they gave him an option. Are you so upset or so fearful that you'd rather stay here in our protection, or would you rather go to Guatemala? He voluntarily said, it's not that bad, I'll go back to Guatemala. The judge is mad about his own decisions and is going to require him to be brought back to the United States in spite of the fact that he already had a full hearing, full orders in front of an immigration judge, removal orders, broke into the country 3 times illegally, and is now apparently entitled to all of the protections of the United States government because of his fear of God knows what in some other country somewhere else. So Judge Murphy out of Massachusetts is obviously a horrible judge, and his name should ring through the ages as a judge who is in love with illegals who are entering our country illegally, overriding the Secretary of State, overriding Kristi Noem, overriding the American people, so that he can bring gang illegals back into America who claim that they're under fear. So that came out on May 23rd from the judge. We'll see what the Trump administration says in response to this. They have not responded to it quite yet, but we know that they will, and we'll keep our eye on it. So thank you for subscribing and joining, my friends. And of course, we'll see you back here when Trump responds. All right, one more update on the day, my friends. And then it's time to hear from you. And here's what the Democrats are up to in strange times ahead. Democrats are now targeting men. They say men don't like Democrats because, we're men and they're not. And they don't want you to really be a man in the Democratic Party. They want you to kind of chop a dick off of me or something like that and come into their new ideology as a non-gendered, non-partisan person who just can be recreated in their image, which is disgusting. But now they're focusing on fixing this somehow. And the New York Times is enlightening us as to what this plan looks like, and it's pretty hysterical. One longtime researcher now has a new technique. She's a Democratic researcher. She uses this technique when she nudges voters to share their deepest, darkest feelings about politics. She went into this. After around 250 focus groups of swing voters were analyzed, a few patterns have emerged. Republicans are seen as apex predators, baby. Heck yeah. Lions, tigers, sharks, beasts that take what they want when they want it. You're damn right. Democrats are typically tagged as tortoises, slugs, or sloths. Slow, plodding, passive, and just all around disgusting. So Ms. Shanko Osario perked up earlier this year when a Democratic man in Georgia suggested that a very different kind of animal symbolized her party. He said they're like a deer, in headlights. Says you stand there and you see the car coming, you're going to stand there, you're going to get hit anyways. Yeah. 6 months after Trump swept through battleground states, the Democratic Party is still shifting through the wreckage. Standing has plunged to startling new lows, 27% approvals, weakest since 1990 after a total defeat. But communities the Democrats had come to count on for a generation, young people, black voters, Latinos, all veered towards the right, some sharply. And unlike 16 when Trump won, his victory last year could not be waved away as an outlier. He won the popular vote this time too, baby. The stark reality is that the downward trend for Democrats goes way back further than a single election. Republicans have gained ground in voter registration for years. Working class voters of every race have steadily drifted towards the GOP. And Democrats are increasingly perceived as the party of college-educated elites. And they, until recently, they loved that, right? We're the college educated. We went to Harvard. The defenders of a political and economic system that many feel is failing them because it is. It's obvious. All the Harvard, all the elites, they're all responsible for probably the biggest failure in my lifetime, maybe ever, which was COVID, where they were supposed to have all this technology and competency and scientists and everything. They were morons. They couldn't even get masks that didn't work into people's hands. Over a long period of time, our party overdrew our trust with the American people, says Rob Flaherty. That's hilarious because Rob Flaherty was the same dude who was in the White House who was sending emails to Facebook saying, censor these COVID people. Remember him? Why aren't you doing more on this? Screaming to all the social media people. The Democratic Party's tarnished image could not come at a more inopportune moment for them. In this era of political polarization, party's in trouble. The New York Times is beginning an occasional series of articles about the Democrats and their predicament, how it got here. The first challenge is that it's not just Republicans who have soured on the Democrat, it's also Democrats themselves. Yeah, how could you still be a Democrat after they told you Joe Biden was amazing and you bought it like hook, line, and sinker? Could you imagine that? You have like a Biden sticker on your car? Like, oh, he's vigorous. Don't worry about it. Telling all your friends. Oh, man, it must feel so stupid. The Democratic base is aghast at the speed at which Trump is undermining institutions, the democratic institutions, and reversing progressive accomplishments. They spent the last 40 years building these. And at the lack of resistance from congressional leaders. What are they going to do? They know they got caught. They all got caught with their hands in the cookie jar. Trump just called them all out. They're not going to say anything. Primary challenges are on the rise headed into 2026, often along generational and ideological lines. Somebody called Jason from Colorado a Democrat. He says, there is fear. There is anxiety. There are very real questions about this path forward. Says, we're losing support in vast swaths of the country, in rural America, in the Midwest, and places I'm from. People that I grew up with who now support Trump used to be Democrats. Yeah, it's not like a Republican thing either. Like this idea that the Republican Party has captured all this, like get out of here. Lankford, Romney, McConnell, Tillis, all of them. Terrible. Wouldn't vote for those guys at all, ever. People that I grew up with who now support Trump used to be Democrats are all walking away, just like the Republicans have walked away from the Republican Party in favor of America First, which happens to be under the Republican name right now, but it's not Mitch McConnell Republicanism. Even the gender gap, which had long benefited Democrats, helped Republicans in 2024 as men swung harder to the right. Now, what about the men? Top party officials, activists, and donors are broadly weighing how to rebuild and to talk to voters. Fierce ideological debates over policies whether to push for stricter stands on immigration, defend transgender rights less forcefully, or embrace anti-corporate economic populism are already playing out in the Capitol on the Nation 2028 campaign trail. And we did a segment, I think, with Rahm Emanuel earlier, and he's got, he's working out his shtick, and it's starting to sound a little bit better. But how are you going to win a Democratic primary if you're taking a tough stand on immigration, where you're not defending the trans? All political parties, of course, face time in the wilderness, and by some measures, this is far from the bleakest outlook they faced. Reagan had a 49 state romp, and Trump is doing well. Trump twice cracked the blue wall. Parties saying they have to find new ways to compete, and they're working on it. This is hilarious. So for now, Democratic donors and strategists have been gathering at luxury hotels to talk about how they can empathize and win back working class voters. Maybe they shouldn't go to the hotels. Maybe they should just go to a factory somewhere. Or maybe they should go, actually get a job with people who build things. Go swing a pick for a day. That'll show you a lot more about the working class than sitting around getting hors d'oeuvres at a Ritz-Carlton, idiots. Commissioning new projects that can read like anthropological studies of people from faraway places. It's bad when the New York Times is mocking them, right? This is mocking from the New York Times. Wild. The prospectus for one new $20 million effort. Could you imagine? Could you imagine if the Republican Party dumped $20 million into right-leaning causes? I don't think they ever do, really. I mean, like social media causes like this or something. They don't. Obtained by the Times, here's this new plan, aims to reverse the erosion of Democratic support among young men, especially online. It's codenamed SAM, right? SAM. It's going to go get all these dudes. Speaking with American men, a strategic plan. Wow, let's see what's inside. Promises investment to study the syntax, the language, and the content that gains attention and virality in these spaces. Wow. All right, dudes. They're going to buy advertisements in video games, among other things, because that's where all the men hang. Above all, we must shift from a moralizing tone, it urges. Stop lecturing us about our lives, I guess. It's good advice, yeah. Trump's diminishing popularity. It's not diminishing. Trump's numbers seem to be... No, it's not. Mr. McCreary, who lives in Alabama, cautioned against taking the wrong lessons from any successes in 26. He says, our party's brand is so repellent. The midterms mask the Biden problem. A good 2026 midterm, we should not let that mask a deeper problem. And voters are hungry to actually, for people to actually stand up for them. So they're struggling. So there's Sam. I think I saw Margot Cleveland said it's very interesting how they pick like a neutral name. It's like Sam. It's like, could be a dude. It could be a dude, could be a female, could be whatever. Anyways, that is what the New York Times said. And speaking of dudes, Macron just got popped in the face by one. This was happening earlier today. Not really the best segue from what we were just talking about, but a fun clip. Here is Macron getting jacked in the face by Bridget. Whoa! Oh, man. Was that a double fist? Let's see. Two hands. I'm pretty sure there were two hands on that, man. Look. Here we go. Right there. There were two hands. One right there. And there's another one. Man, a double push. Ugh. That's pretty manly behavior right there. Pretty aggressive. Hi. Yeah, how we doing? And then they walk. She doesn't grab the hand, or he, whatever the pronouns are. Would you like to grab my arm? No. Lucky I don't pop you in the face again. All right, so maybe the Democratic Party can take some hints from the testosterone-infused Bridget Macron, who's now popping her husband in the face. And maybe they can incorporate that into their study of men. See if that works for them. I doubt that it will. All right, my friends. Well, it's been a beautiful day and a beautiful stream. If you're just joining us, quick recap on what we talked about. Of course, we said what's up and shout out to our amazing veterans, men and women still serving, and those we've lost who've fallen and given the greatest sacrifice ever possible for their country, for liberty and for freedom. We shout out all of our amazing men and women on this Memorial Day. So did President Trump. We had a quick update. We said a prayer for peace together here, and we have another pause coming up at the 3 o'clock hour for that moment that the president articulated for us. We got to see some activity at the Tomb of the Unknown Soldier and paused in honor of those we love. We also then talked about the Supreme Court and read through this filing, in this case, DEI fraudsters now going to jail, getting convicted. Clarence Thomas, though, has some concerns about that. Says, you know what? Actually, the DEI fraud had nothing to do with the contract. The contract was for painting a bridge. The fact that the bridge got painted by white people, maybe, or non-blacks or non-South Asian Americans or non-whatever other approved DBAs, DB advantaged businesses, they are now going to jail. It was a fun read. I thought Clarence Thomas gave us a nice contrarian or alternative analysis there. And then we talked about Judge Murphy, who doesn't care at all about what Rubio says, doesn't care at all about what Article 2 immigration judges say, doesn't care really about the executive branch at all, says, I love gay illegals and they're afraid of getting attacked. And so you're ordered to bring them back to America, no matter what the repercussions are. Judge Murphy out of Massachusetts is a terrible judge. And we're going to continue to cover this case because it's going to, I think, be spicy. Trump has an order, bring this dude back. We'll see if they do. Then we talked about the whack job Democrats who are using a SAM operation to try to target men. And they're going to be advertising on your video games or something. Good luck to them. Actually, we hope they fail, and they will. So, my friends, what a beautiful stream it has been. I hope your Memorial Day is beautiful. And I'm really grateful you joined us on this stream. Now it's time to hear from you. Thank you for supporting our work. Thanks for sending in these amazing donos. Thanks for becoming membos. We'll come back tomorrow. We'll be on the regular stream tomorrow. Membos stream in the morning, 9 a.m. Pacific, 12 noon Central. Regular show back at the regular time as well. We got some great comments in the house. Hey, what's going on? We got Donut clipping for us. And Carrie B clipping for us. Thank you for these. Hey, what great way to start the segment here. What's up? Memorial Day. Remember and honor. Thank you, Donut, for clipping that for us. Hey, Keith. Shrimaniac is in the house. Great to see you, Keith. Thanks for becoming a membo. We're not doing a membo stream today. We still got some friends in town, so we're wrapping up. We're going to close out the week with the day with them, and then we'll be back tomorrow on the regular schedule. So membos, we'll see you back tomorrow. Jack Paddock, and you may grab the Saturday stream. We did do a Saturday stream for membos, so check those out. What's up? Ollie in the house. Great to see you, Ollie. What a nice invite. Welcome aboard. Red Torch is in the house. Not Gullible. Also great to see you, Not Gullible. Thanks for becoming a membo. We'll see you tomorrow on the members only Tuesday morning stream. Wes Downer, were there any dissenting opinions? No, it wasn't. On the DEI contracting case? No, we read through the whole thing. Didn't see anything over there. Yep. Nothing over there. Wes Downer. Thank you for that. Seems like it was pretty uniform. Maybe some different, like Sotomayor might have had a different rationale, but she concurred in the judgment. Knox Bierman. What's up, Knox? Defense attorney in Texas says, hey, blessed Memorial Day all. My first husband worked for Granite Construction, a huge company that got way due to partnering with Monarch Construction, which was basically the only black guy in Animas, Colorado, who happened to have a backhoe. The partnership allowed for massive government contracts all along the Colorado River. This was amazing. So you're like the one black guy in like that location. You get like 7% of all the contracts because everybody has to work with you because you're that one black guy. Pretty great. So, yeah, sounds like it's really correcting some of those disadvantagedness, right? Thank you for that, Knox. Hey, Michael Malone. What's up, Michael Malone? Great to see you. Thank you, Michael. Thanks for becoming a supporter. Thanks for supporting our work. Jennifer, what's up? Happy Memorial Day to you and yours, Robert. Thank you, Jennifer. You too. Hope you're having a beautiful day and doing something enjoyable. Something enjoyable. We got this one from Doan. The first person to mention race loses by default. Yeah, it's kind of... It's an interesting dynamic in that DEI case because it's unconstitutional to scrutinize and to categorize people based on race, but the government put it in their contract. So, like, what are you supposed to do? go to jail, I guess. Just go to jail. Hey, Buffalo Betsy, I wonder if the recent SCOTUS fraud decision has any implications for the Pfizer whistleblower case, the Brooke Jackson case. Interesting, Buffalo Betsy. I don't think I'm familiar with that one. The Brooke Jackson case. She was a whistleblower that was yeah, I'm not sure if it would. Did she have a contract? Was there fraud? Was there fraudulent inducement? Interesting. Good to see you, Buffalo Betsy, but maybe she's blowing the whistle and the fraud was from Pfizer, right? Hey, Uncle Bozy. My fiance was a Marine who retired after 20 years of service. Man, thank you to your fiance for that service. She worked for an environmental company at Cap Lahoon. She was offered a figurehead position as 51% owner and president at another company with an office overlooking the White Oak River, and she didn't even have to go to work. So that company could get federal contracts based on her sex, ethnicity, and her status as a veteran. To her credit, she declined. How about no? You're not going to just use my labels for your own financial profit. She was a true patriot and a Marine. God rest her soul. She died in 2009. Beautiful woman. Here she is. I still love her and miss her every day. Uncle Bozy, man, I feel that, man. Thank you for sharing that. And she's beautiful, and may she rest in peace. We will be returned again, but not yet. And we thank her for her service to our great country. We thank you for being supportive of her in the time that you had together. We're sending you good love and energy today, my friend. I hope you're doing well. Thanks for sharing that with us. Beautiful, beautiful picture, man. Beautiful. The Taco Vendor. Thank you, Taco Vendor, for signing up, my man. You too, NTX Nancy. Amazing to see you. Okay, so we'll do an after party today and say what's up to our new membos. So we'll do some locals comments. So stick around after the show's over. We'll come back, membos only party as well. Hey, Leonard. Dems waited until after the 24 elections to release all the stuff about Brandon, just as Brandon waited until after the 24 elections to pardon Hunty. Yeah, and I think they're all kind of trying to salvage their reputations now. And you'll notice that all the anti-Biden talk, they're trying to parlay that into anti-Trump talk. They're trying to say, well, we just discovered all this about Biden, so we need to pass legislation now to make the president much more transparent. So what happened with Biden never happens again. And so that means we have to put all these controls over Trump. And like the Biden problem will be fixed with Trump. No, we don't have concerns about Trump. We had concerns about Biden and the cover-up. Good to see you, Leonard. What's up, Doan? Do rumors of treason charges against Alejandro Mayorkas emanating from the Justice Department sound legit? Not to me. If true, full discovery could set dominoes up quite nicely. Yeah, I doubt it's true. We're talking about Pam Bondi. And yeah, I highly doubt it. Discovery would be nice, but I'm not holding my breath on anything like that. Kendall Links. Hey, Kendall Links. Good to see you. 1 month as a member. First month's the hardest. Gets easier from there. Says OCG chose to be flamboyant, purposely being a target. Well, yeah, I know. And that's, I guess, our fault as America, that in Mexico and Guatemala, they're not as progressive and accepting as we are. So we have to take every single gay person in the world, if they're under any sort of prejudice out there. Where else are they going to go? They're going to be attacked. We have to save all of them. Okay, Jacob Hawley, I'm a progressive. What's up, Jacob? Thanks for watching the show, Jacob, and being here. I'm 23 years old. I voted for Trump in 2024. Amazing, Jacob. I hate illegal immigration and racist DEI identity politics. The Democrats lost me as a voter. If they're losing me as a voter, you know the Dems have a problem, man. Jacob, we're glad to have you here, man. And I'm sure that's a transition you're going through, not in that term, but I feel the same way in many ways about the Republican Party. Like, I'm pretty disgusted by the Republican Party. Absolutely disgusted by it. If it was not Trump who was leading this, I think it would be a very different environment. And in other words, like Trump is breaking this old two-party dynamic a little bit. We just want a strong America, right? If you're a progressive person on other issues, but you're on board with immigration and this racism stuff and all this, we've got a lot more in common than I think that we think. And we don't have to We want a strong America. And I appreciate the fact that you were, kind of brave enough and not, free thinking enough to make that distinction in your brain and make a change politically and voluntarily. I think that a lot of progressives would never do that. They would, they never have the mental capacity or fortitude or integrity to do something like that. They're just locked in forever. And that is not freedom. That is being a slave to a political party. So amazing. Great comment. Thank you, Jacob. It says another one, and it's kind of funny too, as a progressive, I actually see Trump and the GOP as the liberal progressive party. I think the GOP is kicking out the neocons and the paleocons and returning to the GOP of Theodore Roosevelt. Yeah, it's interesting to say that, Jacob. And when you start talking in that concept, when you start saying, well, if we're going to spend trillions of dollars, like what if we spent that for us and not for Ukraine and foreign wars and all of this other foreign, what if we spent that for us? Does that make us like socialism, like socialists or progressives or something? Like rather than spending $100 billion, I made this point many times, or maybe $200 billion on Ukraine, what if we spent $200 billion on nuclear energy in America and every state got a new nuclear power, like nuclear power plant, and we all had low energy for the rest of our lives or free energy? Like what would that do for the country? Is that a socialist progressive thing? Or is that just, well, we have a country that we want to be better and have more, more utility for our people. Like there should be a benefit to being an American and paying all these taxes. If we're going to pay all these taxes, shouldn't we get something for it? But is that communism? Is that socialism? Or is that just a strong country? Right? The neocons and the paleocons and all these other people would say that you're a socialist. Like I just want a country that's functional. I want my money and my taxes to be going to something useful. Doesn't make us a progressive. And Trump is talking more in alignment with that. But I think the old guard was like, no, you can't have anything good for your country. You have to accept illegals and spend on these wars. And that's going to be good for your country. It's like, what are you talking about? That's not conservatism at all. So I agree, Jacob. It's great to see you, man. Great comments. Larry, of course they don't like men. They like pizza and pupusas down there, apparently. Yeah, they'll kill each other for pupusas. So much killing, they have to come to America. Thank you, Larry. First month's the hardest, Larry. Easier from there. Leonard S., what's up? Hey, one of the first major parties in the U.S. were the Federalists. This party disappeared around 1820 due to widespread opposition. Yeah, the Federalists were maniacs in many ways. Like the early founding era was not that great in terms of... The Federalists were pretty rotten, actually. So, I mean, they were good in many ways because they helped, get the Constitution passed, but they did not want the Bill of Rights in there at all. The Bill of Rights was an anti-Federalist feature. In fact, many people who didn't even sign the Constitution were the ones who shoved that Bill of Rights in there. Thank God they did. James Madison didn't even want the Bill of Rights. So once the Federalists won, they put them all in the Supreme Court, and then the Federalists started to prosecute the Jeffersonian Republicans, essentially, at the time. And the Jeffersonian Republicans, there was one real big battle with Samuel Chase, was the first and only Supreme Court judge who was impeached. But he was prosecuting these Republicans and giving them the death penalty and imprisoning them and stuff like that. Like they were political maniacs. And a lot of what the anti-federalists had to say, I think, has been vindicated over these years. Doan, the left's war on patriarchy is broad in nature. Winky face. Broad in nature. Yeah, so I think even globally, it's a good comment, Doan. Hey, Off-Label Podcast says, speaking of dudes, nice segue on that. Thank you for that. It's kind of a hard pivot. Yeah, so speaking of Democrats going after dudes, now let's talk about Bridget McCrone. Thank you, Off-Label Podcast. Great to see you. What's going on, 200 Watt Studio? Hey, just a couple of married French dudes fighting. I know. Yeah, those French dudes get pretty aggressive. Pretty, Is that domestic violence? Should be charged. Hey, SD Gold Star Mom. Shout out to SD Gold Star Mom. Says, great show as usual. Thank you, Rob. Thank you, SD Gold Star Mom. We got Rub Some Dirt on it. Whirlpool Galaxy says, thoughts and prayers to you, SD Gold Star Mom. And again, thank you, SD Gold Star Mom. Hey, what's up, Neuro D? Shouting out King of Biltong. Whoa, we got a nice code over there. Buy some meat at Biltong USA. B12, creatine, iron, and zinc. A great addition to a healthy diet. You guys even have a promo code over there? Robert. Use code Robert over there. You'll save 10% off. That sounds great. Biltong USA. If you like Biltong, Anton has the best. B12, creatine, iron, zinc, Neuro D. Good to see you guys. Shout out. Get some biltong. Buffalo Betsy. They died so we could speak, worship, and stand unafraid. The First Amendment is their legacy. Memorial Day is our promise to protect it. Yeah, man. And we're so grateful for that. I mean, it's such a gift, this First Amendment, this right to free speech. It's a God-given right that we have. And other countries don't have that. We have that. And we have a lot of people who gave the ultimate sacrifice to protect it. And we are so grateful. Thank you for that. That was a beautiful comment. Buffalo Betsy. What's up, Knox Bierman? I do hope everyone had a long, lovely weekend with great times, good food, and amazing memories. My grandbaby twins turned 1, and oh, the fun we had. That's amazing. Happy birthday to grandbaby Knox over there in Texas. What's up, Buffalo Betsy? Robert Barnes is her attorney. She's a RAND trial site from the Pfizer trials. She also brought a QTAM case on behalf of the people. How have I not heard of that one, Buffalo Betsy? Thanks for educating us on that. Brooke Jackson Pfizer whistleblower case. Woo. Okay, cool. Thank you, Buffalo Betsy. Shout out to Robert Barnes. 200 Watt Studio says a lot of black men have backhoes, 304s. Is that right? Yeah. I mean, I don't see why not. Why not? Hey, what's going on, Kelly? Hey, says, caught you on Good Logic, and you bring the truth every time you speak. Thank you, Kelly, for saying that. Shout out to our friend Joe, Good Logic, right next door. Great channel. Lots of Diddy case coverage. Good stuff happening there. Helps with my worldly anxiety from crooked Dems I trusted for 10 years. Gosh. Yeah. Yeah, and I can understand that with the Republicans, too, and with the government in general. It's like, well, they're competent. Like, they have the CDC. They have the military. They're smart. Oh, wrong. Knox. This one. 15 legendary military dog breeds to remember this Memorial Day with. That looks like a great link. 15 legendary military dogs. Amazing. Former. Based on some of the opinions of the inferior courts, it looks like they want a showdown between Article 2 and 3 courts. Yeah. SCOTUS could have pushed the POTUS into the position of following the orders of Article 3 courts or sacrificing his vision of the country. If SCOTUS wants a urination contest, we can give it to him. POTUS should have a very private conversation with the Supreme Court. Yeah, well, he's basically saying it out loud, like his Memorial Day post was ripping on them. Hopefully the Supreme Court and other judges will save us. Talking to you, John Roberts, Amy Coney Barrett. Doan, what's up? The Brooke Jackson versus Pfizer whistleblower case that Pfizer won could and should be overturned when probes revisit the questionable clinical trial protocol. Yeah, and there's a lot more coming out on that too. I think, did the FBI just announce that they were going to be doing something on that? I think they're going to be probing. I think I saw that they're going to be probing something else. We love those probes. We want to probe the hell out of everything over the last 4 months, you know. Big probes. Big penetrating probes. We want to see everything, all the disgustingness. And I know that sounds weird, but it's true. All right, my friends, thank you so much for sending those in. What a beautiful stream this has been on this lovely Memorial Day. Let's say hello to our friends on X, and then we'll do an after party. We'll hang out for a few minutes. We'll debrief, take some locals comments, hang out with some YouTube members and our locals friends. And then, of course, we'll be back tomorrow for the regular schedule. All right, let's see what we got on X. Any comments over here? Oh, that's not the video. No comments on X. Nobody's watching over there. Oh, man, X has been a little bit wonktified lately. Or people just hate us over there. I don't know, one way or the other. Anyways, it's nothing going on over there. But thanks for seeing you on X. Now, my friends, we will leave it there on the day. What a beautiful evening, day it has been. Afternoon it has been. Happy, honorable, beautiful Memorial Day to all of our friends out there, to everybody across America. We will pause for the evening, but we're not done on the week. We're coming back tomorrow, my friends. And so members, tomorrow morning we'll be back regular time, 9 a.m. Pacific, 12 noon Eastern for the members stream in the morning. And then back on the evening show, 3 p.m. Pacific, 6 p.m. Eastern time, back on track tomorrow. And it's going to be a great stream. So once again, I want to thank you for being here. Thank you to our amazing mods and meme smiths who mod the fort down for us and keep things nice and orderly. Ultra shout outs to Donut, Mind Me, and Carrie B for clipping for us. Of course, we also want to thank Janek, Dog Digger, Neuro D, Just Rhonda, K Bean, John, and the rest of our friends who keep this show nice and beautiful and orderly. We are going to leave it there on the day, my friends, but I want to thank you for joining us. We are coming back tomorrow to get into it again. And so until then, I hope you're having a beautiful week. And tomorrow, I hope you come back and join us because we are going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Happy Memorial Day. Have a peaceful, restful, beautiful evening. We'll see you right back here tomorrow. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers, we won't be denied. Watching the watchers, eyes open wide. Fighting for freedom with nothing to hide. So drop a like and don't forget to share. Bring a friend who's ready to care.